Hello and welcome to episode 6 of Crystalcast. My name is Ross and I'm an immigration lawyer.
My name is Juan and I'm a registered migration agent.
Juan, good to see you again.
Good to see you, Ross.
We've got quite a big episode today.
Yeah.
And now we'd like to thank our sponsors who allow us to bring these episodes to you every week free of charge. We just wouldn't be able to do it without them.
Yes, Ross, and they are 123 Accounting, also migration insurance brokers.
And we've got Migration Strategic Brokers and Oasis Keen Property. Now, Juan, we do have some substantive news this week. Part of the migration strategy was to introduce the Genuine Study Test, and it looks like Genuine Study Test is going to be implemented on Monday.
Yeah, that's really important. And I think it's a bit of a big subject to speak about.
Yeah.
And we're going to be covering that next week.
I believe so, yes, given the fact that the regulations have now been released, which is good. And what I'm hoping for next week is we'll have a bit of policy guideline around it. So that will be our topic of the week.
Absolutely. And it's really important to have this in mind and keep prepare yourself and alert your clients about these changes. But we're going to be covering this more in detail next week. And today we would like to introduce to you Yin Chu, immigration lawyer at Legal Vision. She's a friend of ours, a partner with us, and how are you today?
I'm good. How are you guys?
We're good. Welcome, Yin. It's good to have you. We want to discuss with you some of the sponsorship compliance around work visas. And I know that you do a lot of work visas in your day-to-day job, so maybe just tell us a little bit about how that works.
Yeah, obviously as part of undertaking employer-sponsored work, employer-sponsored visas, there's often a lot of crossover with an employer's employment obligations, and how that also extends to their sponsorship obligations per the Migration Act as well. So there is, I can deal with ABF audits, I can deal with just initial training and compliance, I can deal with sort of initial discrete questions around an employee's work rights, and yeah, it's all encompassing. It's very broad. It's always different, and sometimes it can go all the way to cancellation or bar sponsorship, things like that.
Yeah, and it is interesting because I suppose, we do quite a few audits here. What do you think triggers an audit? Clients get a little bit, I suppose, nervous when you tell them you've got an audit coming up, or maybe there's a notice of intention to take action. What would generally trigger that sort of response from the Australian Border Force?
It depends on the industry, that's one. Some industries are more prone to audits.
Yes.
Random audits, more prone to scrutiny because of maybe a perceived notion of how they operate by the ABF and by the Australian government or other state or federal government agencies, and then others it's based directly on whistleblowing or complaints and stuff like that, so there may be some businesses or industries that may never be impacted because of what they do, but it doesn't mean that an employer or a sponsor should not be prudent in understanding what their obligations are and actually putting measures and steps in place to ensure that if that does happen, they're well prepared in that event.
Yeah, definitely. And I suppose just going off the back of that, being well prepared, what sort of documents could be requested during the audit?
So many.
We know that too well.
so many. So if you've got a prudent client, meaning like the client will actually tell you that they're under investigation or they're being contacted by the ABF, or they call you and say, by the way, we just got a surprise visit from the ABF. Then there's ways to kind of, manage it and mitigate it and understand, what they're looking for. It's after they get the NOITA, it's after they've already provided or made things available to the ABF that it can be quite challenging. But you know, they can do all sorts of things. They can interview the employees of a business there. They can ask for records, any type of records, particularly in relation to paying employees, paying sponsored workers, their payroll system, their employment contracts, all those sorts of things. Yeah.
Yeah, and I suppose also just some of the recent cases that we've seen, when an employee gets audited, they might have trouble explaining how the award is applied. So, for example, applying overtime. What advice would you give to such employers that may not understand how award provisions work?
Get employment law advice. Like, I'm no joke. No joke at all. It's because we're immigration lawyers and some of us may have employment law backgrounds like I do, but it's not to the extent of my colleagues in my workplace as well. But I may understand it broadly. But if you're a migration agent and you know you have, again, some basic understanding of employment law, modern award interpretation is super complex. Really complex. Yeah. That's no joke. If a modern award does apply to your client or the industry or the business or things like that, they got to get employment law advice, where part of that advice and assessment is that they will examine, you know, what roles they're actually in, what occupation and pay classification pertains to those positions, and then they will provide that advice accordingly. Like, this is the proper, you know, pay guide for them. And then the pay guide, you know, changes too.
Exactly.
So you got the modern award, but the pay guide also that is attached with the modern award changes. It's meant to be updated year on year. And then you've got, how does the modern award apply in situations with enterprise collective agreements? It gets really complicated.
It sure
gets
does.
really complicated. You know? Yeah.
Yeah, so I guess one of the key messages I'm getting from this conversation is that it's good for those employers that are sponsoring foreign workers to be prepared since the moment they start the process to get familiar, not only with the migration bit of it, but also with the employment side of it. It's like, so they get a notion on how to be compliant with the obligations of the sponsor.
They're not mutually exclusive. They've got to be considered together. I usually, like, it depends on the client. A lot of the clients that we work with, and probably you work with as well, because a lot of them maybe are national businesses or international businesses. They're established. They probably have an internal HR team, all those sorts of things. They're more likely to already have those processes, advice, systems in place. Your smaller businesses tend to be more prone to being, you know, unaware or ignorant to what their sponsorship obligations are, and sort of only focus that there's kind of one set of rules because they've sponsored a migrant.
Yeah.
So then the employment law framework, I don't think it's intentional. It's just an ignorance and unawareness that the employment law framework, as it pertains nationally here too, would apply to them as well, that migrant worker. So definitely we're finding, even with smaller businesses, you just got to be on top of that as well.
And I think also, you know, one of the things that we advise our clients is to, like you said, you know, you can't plead ignorance. If you get a NOTA, you can't say, well, I wasn't aware that a particular award applies, because that's almost sort of walking into a trap, saying you don't know your sponsorship obligations.
Yeah, having said that, you know, I've dealt with quite a few cases where it's clearly inadvertent. It's clearly like we really didn't know.
Yeah.
We have now informed ourselves, and we've shown evidence of that. We've rectified the situation, all that sort of stuff. And you know, the good outcome around that is they get a warning.
Yes.
They get a warning, like, here's a fact sheet. Here's a fact sheet of your sponsorship obligations by the ABF, and they're like, there is some level of understanding that ABF will adopt. It's usually around repeated offences over the period that they're the monitoring period that they're assessing and if there seems to be these repeated offences, you know. But I think also, I mean, that's been my experience in the past, but then there's a new legislation that strengthens the ABF's powers now.
Yes, exactly.
Which means that, with that comes probably lesser tolerance around, the defence of, sorry, I was not aware.
Exactly.
Yeah.
And I think, we do deliver CPD sessions, and I would say in my employer-sponsored CPD sessions that you need to be aware of what those frameworks are, and I suppose it just comes with the sponsored framework. It's called employer-sponsored visa. So there needs to be that level of awareness that the sponsorship obligations continue. But I did want to segue a little bit into adverse information.
Oh yes.
So Regulation 1.13b.
Yes.
Because I suppose one of the things that we need to keep in mind, it's not just to do with the sponsoring entity, it's also to do with any associated businesses or persons. Can you maybe share your insights a little bit around that criteria?
Yeah, it's adverse information is an interesting beast because it's really broadly defined. But so it gives you some examples, but it's not exhaustive. You know? And so you really have to make this assessment based on your understanding of the definition and then past experience too. It can actually, adverse information can actually pertain to any relation to the entity.
Yes.
So obviously any of the directors of that entity, any of its officers, and I'm talking about office holders. So, sometimes it may pertain to some employees that are considered representatives. But we're really talking about when you look at the asset company extract, who's the directors, who's the shareholders, who's the office holders. Those are the ones that are responsible. But then it also pertains to any entities that those shareholders, directors and office holders may be associated with as well.
And I think there's a bit of confusion around that, thinking that if there's an issue with this particular entity, well, maybe we can just focus on another entity and get sponsorship there.
No way, unless it's completely separate. But even so, if you were to set up another entity and you got, like a friend or a colleague to do it, is there a relation? Is there an association? Can you connect it back to the former entity?
Yeah, it's really important because there have been many cases where an entity gets a bar on a sponsorship, and then the owners try to within that same body trying to reincorporate the sponsorship, and it just wouldn't work.
No, it doesn't work.
So I think it's really important to guide our clients on how to avoid those situations and avoid extending that impossibility to keep sponsoring, because we have other cases where it's been a bit disastrous, the client trying to get back into the game and simply not being able to.
Exactly.
So I've offered some solutions.
We love solutions.
May I give you some solutions?
Solution checklist.
Because there's somewhere, after you do all that, you can think, there's some circumstances where, you identify adverse information, it can be disregarded and everything's fine. There's some circumstances where they've been under an audit and you can explain it and they don't receive a bar or cancellation. So it's happened quite a bit, but on the flip side, I've had it where it hasn't, because the adverse information is too great, there's too much of it, and it's over a extended period of time, and it's a repeated pattern, and similarly too with the breach of the sponsorship obligation, so you can't get around that. You can't go set up a different entity. So what I've often said to some clients is find a recruitment company that has an on-hire labour agreement. And we don't get any money for it, but it gives the client an option. Maybe you do. Maybe there will be some recruitment companies do have that kind of referral arrangement. But anyway, what I'm saying is that's definitely what I have advised some clients is work with a recruitment company that has an on-hire labour agreement, so you can retain that skill in some way, because they're going to on-hire it to you, that talent. And then as you move past the bar, past the cancellation, because there's a period, that it's barred or cancelled for, then you have an opportunity to apply again.
Yeah, and that's a really good point. I love creative
It's practical.
thinking. It's practical.
It's practical.
Exactly.
Yeah.
And that's one solution. But I think also, and I think I know what you're going to say, the after effect of the bar as well
yeah,
can potentially
yeah.
be an issue.
Absolutely. So that's why I wanted to dig into
Oh, yeah.
into the definition of like associated entity and how this would affect in the long run. But thank you so much, Ian, for these solutions and these insights. It's lovely to have you here.
Thank you.
Thank
Thanks
you.
for having me.
No worries, and it's always good to hear practical tips.
Okay.
Thank you.
All right. So in today's game, Ross, I can see a country in your screen that you obviously don't know,
Yes.
and vice versa. So the idea is we're gonna ask each other questions and try to guess what country we're holding.
Who comes up with these games?
All right, so you ask the first question.
Okay, I might just start with continents first. Am I in South America?
You are.
I thought so. Okay.
Am I in Europe?
You are. Yes.
Ah.
Okay. Am I Colombia?
No. Am I famous for food?
No, I
No?
don't think so.
Okay.
No.
I'm gonna go for the obvious. Am I Brazil?
No. Am I a Nordic country?
A naughty country.
A Nordic country.
Right. So you are Uruguay.
Oh my god!
Am I England?
Yes, UK.
Yes, UK.
I won. Thank you so much for being with us today. It's been good to have you in and
Yes.
to have had that conversation.
100%. I've certainly taken a lot out of it, and I look forward to our next episode discussing the genuine study test one.
Yeah, that's gonna be really good. Stay tuned.
Thank you.